The history of the Supreme Court can be divided into a few major periods. From 1789 to 1865, the main issues were federal supremacy and slavery. Chief Justice Marshall solidified the supremacy of the national government. His successor, Chief Justice Taney, was more favorable to states' rights, but is most remembered for his rulings on slavery in the Dred Scott case. Between 1865 and 1937, the main issue was the relationship between government and the economy. The court limited government regulation of business seeking to uphold private property rights. From 1938 to the present, the major issues in the court has dealt with are liberty and equality. Under Chief Justice Warren, activism became a much more dominant part of the court. More recently, there have been some movements back towards states' rights. The federal courts have jurisdiction when dealing with federal questions, issues involving the Constitution, U.S. laws, or treaties, or in diversity cases involving people from different states. Most federal cases begin in the district courts because they have original jurisdiction. Cases may only reach the circuit courts through appeals because they only have appellate jurisdiction. The Supreme Court has original jurisdiction in cases involving international entities or conflicts involving two or more states. Other cases must reach the Supreme Court through appeals. The writ of certiorari allows the Supreme Court to choose its cases if at least 4 justices wish to hear it. Federal judges are nominated by the President and confirmed by the Senate. In theory, nominations and confirmations are based on qualifications, but the use of litmus test questions to determine ideology has become more important. When dealing with the district court nominations, senatorial courtesy gives the opinion of senators from the state in the position extra weight in the confirmation.
The Supreme Court is in session from early October until the end of June each year. Once a case has been agreed to be heard, each judge reads briefs alone in their offices. A brief is a document that gives the basic facts of the case, the arguments for the side of the lawyer writing the brief, a summary of the decision previously made by the lower court, and the decisions by the Supreme Court in the past on related cases. Relying on precedent, or stare decisis, is important in how judges decide on a current case. Besides lawyers, interested parties not directly involved with the case, called amicus curiae, can send in their own briefs to help inform the court's decision. Once the justices debate, vote, and come up with their decision, an opinion is written. There are 3 types of opinions: the opinion of the court, which is the majority's view, a concurring opinion, which agrees with the majority but for different reasons, and the dissenting opinion, written by the losing side of the case. These are usually written by the Chief Justice, whichever side he or she is on, and by the most senior justice for the other side. The power of the federal courts has increased greatly over time due to reinterpreting laws and the Constitution. One of the best ways to see this is through what remedies the court imposes. Remedies are judicial orders that attempt to right a wrong found in a case, sometimes changing the circumstances in which thousands or even millions of citizens work and live. The court has also over time become more willing to handle matters that were once left to other branches of government, regarding political questions as less of a barrier to judicial power. The main reason behind this increase in influence is from a more activist stance from judges. An activist judge is one that interprets the general underlying meaning of the Constitution, reading it through the lens of moral or economic philosophy, and applying this to cases. The opposite is the strict constructionist approach, where judges only apply the rules clearly stated or implied in the Constitution. Even though judges aren't elected, they still have checks from the legislature and from public opinion. Public opinion can both restrain the courts and energize them, because when the people are in opposition to the courts, their legitimacy comes into question. Congress has the power to confirm appointments and to impeach through the Senate, to alter the number of judges, and to decide the jurisdiction of the lower courts and the appellate jurisdiction of the Supreme Court. As Congress, the bureaucracy, and the President have come to play more important roles in the lives of average citizens, so have the courts.
Let's talk about politics, culture, and civil liberties. The U.S. Constitution and the Bill of Rights contain many competing rights that can conflict with each other. Sometimes special interest groups are on the opposite sides of a fight for certain rights and liberties. Let's interpret and apply the First Amendment. The First Amendment protects freedom of expression and freedom of religion. The Due Process Clause might have restricted states' rights, but for 50 years the Supreme Court denied that this clause made the Bill of Rights applicable to the states so they could still pass whatever sedition laws they wanted. Another question was whether simply advocating the overthrow of the government could be punished. Basically, during wartime or other times of crisis, personal freedoms are more restricted. During peacetime, people have freer liberties and don't have to worry about rights as much. What is speech? A libel is a written statement that defames the character of another person, saying it is called slander, but suing and collecting damages for libel can only be done if it is proven that the libel was false and that harmed the person suing. False advertising is obvious, and it can be punished if it is proven that the advertising caused a person to be harmed, physically or financially or whatever, by the thing advertised. The First Amendment does not protect obscenity, but because this is a relative idea and depends on the viewpoints of the individual. The court also ruled that symbolic speech cannot be treated like real speech, or else people would have the excuse to do all sorts of illegal things, from burning draft cards to murdering and raping people and committing arson. However, one can burn a flag because the U.S. government has no rights over the U.S. flag. What about church and state? Free Exercise Clause prohibits Congress from making a law that bans free exercise of religion, and an Establishment Clause that says that Congress shall make no law respecting an establishment of religion. In interpreting this ambiguous language, the Supreme Court has adopted the wall of separations principle, which means that the government cannot be involved in religion at all. What about the crime and due process law? The exclusionary rule says that evidence gathered in violation of the Constitution cannot be presented in court. To search a home now, a search warrant must be issued by a judge who is persuaded that there is a probable cause or a good reason that a crime has been committed, and evidence that would prove that crime would be found at the location that the search warrant says. The courts have since begun to decide many cases in ways that retain the exclusionary rule, but gave officers greater freedom, and by incorporating the good faith exception would include evidence gathered even if the search warrant was defective for a minor reason.
Throughout America's history, civil rights has been a highly controversial issue, as some groups were often denied these rights based on race, ethnicity, lifestyles, or beliefs. For the African Americans, civil rights is an extremely important topic, as they were barred from their rights to jobs, voting, education, and even public transportation seating. In the 1950s, as more whites in the Deep South oppressed the rights of the blacks, protesters decided to turn to the courts for help. For example, though it was previously decided that segregation was legal through the decision of Plessy v. Ferguson, it was later appealed by the Supreme Court case decision of Brown v. the Board of Education, which gave both whites and blacks equal educations. Affirmative action also gives minorities equal rights, as schools and jobs ensure mixes of races and genders in their classrooms and workplaces. However, the Supreme Court has made many conflicting decisions over the policy of affirmative action, as they sometimes favor policies and sometimes not. Another group that was denied rights were women. Many of these cases were related to sexual discrimination, such as different ages for men and women to buy alcohol and unequal retirement benefits. Through much protest and campaigning, however, women gained more and more rights that equalized the two genders, as seen in the decision of Roe v. Wade, which legalized abortion and gave women the choice over their bodies. In today's society, another flaming topic includes the civil rights of homosexuals. Though it was decided by the Supreme Court with a vote of 5-4 that there was no constitutional reason to bar states from banning homosexual relations, cities within the state are still able to reverse the ban. Currently, the situation remains unclear, as some U.S. states allow gay marriage while others do not. Whether civil rights will be granted to this group has yet to be determined.
The court is responsible for checking the actions of legislation as well as determining the constitutionality of legislation. It utilizes the process of judicial review, or the power of the courts to declare acts of the legislative and executive branches to be unconstitutional. When the court declares such, the actions or laws are thus null and void. The decisions of the judiciary courts have lasting effects, as the results of past cases are often used in determining the constitutionality of modern issues. Certain issues are of particular influence. Chief Justice John Marshall and the Supreme Court serving with him determined that the Supreme Court could declare an act of Congress unconstitutional, that the power granted to the federal government by the Constitution flows from the people, and that federal law is supreme over state law. In the 1803 case of Marbury v. Madison, William Marbury was designated as a Justice of the Peace in the District of Columbia. Marbury and several others were appointed to government posts created by Congress in the last days of John Adams' presidency. But these last-minute appointments were never fully finalized. The disgruntled appointees invoked an act of Congress and sued for their jobs in the Supreme Court. Marshall determined that the Constitution was the fundamental and paramount law of the nation, and that an act of legislature repugnant to the Constitution is void. When he presided over the case of McCulloch v. Maryland in 1819, the court determined that the federal government was dominant over state government and that Maryland could not pass legislation to impose taxes on the federal bank. The Supreme Court's determination of the constitutionality of actions often allows for the government expansion, and cases can be important in deciding jurisdiction in regards for determining civil rights. The landmark case of Roe v. Wade demonstrated the expansion of government jurisdiction. Until 1973, it was up to states to decide whether and under what circumstances a woman could obtain an abortion. The case ruled for a right to privacy stemming from the Due Process Clause of the 14th Amendment, thus protecting a woman's right to freedom to choose during the first trimester of pregnancy. The ruling has since been continually opposed, but none have yet to overturn it. In Plessy v. Ferguson, it was established that separate but equal facilities were constitutional. However, in 1954, the decision was overturned by the case of Brown v. Board of Education because, as stated by Chief Justice Earl Warren, in the field of public education, the doctrine of separate but equal has no place, as separate but equal facilities are inherently unequal. Brown v. Board of Education was a class action suit, or a case brought into court by a person on behalf of not only him or herself, but for all people under similar circumstances. The case provided for desegregation not only in Brown School, but in schools nationwide.